good morning and good afternoon to in-house counsel from all across America. Welcome to In-House Connect. My name is Shai Mahani and I am the CEO and co-founder of In-House Connect. And I'm thrilled to have you here as always. Thank you for spending your breakfast time or your lunch time with us, or possibly even your dinner time with us. And special thanks to our wonderful sponsor and presenter today, Dave Stevens of the Stevens Law Group. Dave is going to teach us how to audit and structure our organization's IP portfolios. And this is going to be actually the first of a series of events on IP management. And we are very, very lucky to have such a fantastic thought leader on to teach us all he knows about IP. So for those of you who are here for the first time, let me give you a quick bit of background about In-House Connect. In-House Connect started 11 years ago as a New York City-based meetup group for in-house counsel. Every month we would meet up for free CLE. It was hosted by a different law firm, and every 6 months we would meet up for a networking event, usually a rooftop in New York City. I'm hoping to bring it back, so stay tuned for more on that. Over the years, we've helped thousands of in-house counsel connect with peers and outside counsel alike. The group was humming along, and then of course COVID hit, so we couldn't meet in person, so we went online, and it's been a fantastic transition. We've been able to attract a much larger audience of in-house counsel from coast to coast, sometimes across the world. We've been able to facilitate way more relationship and networking building, and we've been able to feature high caliber speakers like the one we have today, who I'm going to introduce in just a few minutes. So this is actually our 36th event of the year so far. And I'm wondering, are you here for the first time or have you been with us before? At 27%, I'm going to round up to 30. It's I went to law school to avoid math, and here it is confronting me. So I'm just going to make it easy on myself. So I'm going to say, welcome to the 30% new people. I hope you enjoy the program and return. And welcome back to the 70%. It's really wonderful to see you again. So that's all I got. Today's event, without further ado, intellectual property management for in-house counsel, auditing and structuring your company's IP portfolio. Our presenter today is Dave Stevens. Dave Stevens's IP practice includes patent prosecution, transactions, due diligence work, agreements, opinions, including validity, infringement, patentability, right to practice, and freedom to operate opinions, counseling, offensive and defensive patent issues, licensing, and litigation. He also serves as an expert witness in technical and intellectual property legal issues, and has been called as a fact witness in enforcement actions, including the many patents he has written. He is also an expert in copyright, including software, publications, products, and artworks, and other copyrightable forms, and open source issues. He works with foreign IP firms and foreign clients with respect to domestic and international patent prosecution, including patent cooperation treaty work. We are so lucky to have Dave with us. He's presented on a number of topics, and it's always a joy, frankly, to hear him speak and to learn from him. So we're very lucky to have him today to help teach us how to audit and structure our company's IP portfolio. And with that, I'll turn things over to Dave to get us started.
Thanks, Shai. I'll try to live up to those expectations. Thanks for everybody for your time and joining me. I know your time is really valuable, and my goal is to give you some takeaway information that you could put to work right away. And of course, when we're done, feel free to reach out if you have any specific questions. These are obviously subjects that I love to talk about, and they can be really helpful. I think it's a lot of people see intellectual property and management, even if you spend time in them, it's a bit of a black art. And I really want to try to clear that up and hopefully make each of you, at least the first steps of becoming an expert in IP. And as I've always, told everyone, you don't need to be a reg number. You have a reg number. You don't have a tech degree to be an expert in IP, especially for your company. There's an awful lot of value you can add and a lot of scrutiny that you can pay to your outside counsel and your portfolio and your general management and practice in-house. So this next slide, if for those of you who have seen this before, have seen me before, I always bring up this slide. It's a Chesbrough slide. It's related to open innovation. But the purpose that I like to use it for is to give you a visual of the type of intellectual property that you have in your company and really the exposure that you have. And it's nothing to be frightened of, but it's something to be aware of. And being aware, especially of the open innovation nature of most companies nowadays, it's good to at least be aware that intellectual property is something that really adds to a vibrant company, and using and leveraging the intellectual property for your company can add an awful lot of value to management and to everyone that's operating in the day-to-day business of the company. On the left, you'll see the old type of innovation. Usually you see these in, like, defense contractors and old time companies where everything is internal, everything is closed, secrets are kept inside, nothing is exposed. But that's not reality for most companies, certainly private companies. What's more realistic is that you have vendors, you have customers, and you open up your innovation because it's a two-way street. You get input, you put output, and there's a lot of collaboration among customers, partners, vendors, and others. And the more aware you are of these, these transaction points, the more that you can understand how your company's intellectual property can be leveraged in all of these different types of relationships. So there's 3 pillars of sustainable innovation culture. And innovation culture exists inside of a company, regardless of really what the products are and what the operations are. The culture inside is an internal thing, and it does reach out outside, and it does collaborate with outside entities. But internally, you really want to have a sustainable innovation culture. And the way to sustain it is to be aware of the intellectual property of a company, understanding how to manage it, and mostly how to use it and leverage it, right? Regularly auditing, structuring, and budgeting your IP portfolio, which is what we're going to talk about today. We're just going to touch a little bit on budget. Again, what Shai was explaining earlier is that this is the first in a series of webinars. We'll get more deeper into budgeting in a couple of months, hopefully closer to when you're setting your budgets for your company. But today we're going to talk about really auditing, understanding, seeing what you've got. What intellectual property does the company have? And even more importantly, what could it have? What more can this company acquire, protect, if nothing else, just be more aware of? Because intellectual property exists all over your company, starting with trade secrets, patents, trademarks, copyrights. And we'll talk about those different things and how to audit those and get some visibility on that. And ultimately, the 3rd pillar is leveraging company IP for revenue and negotiations. So a culture of innovation, it's really about giving your employees the freedom to innovate, to think, to take time and reflect on what is this thing that we're building? What tasks do I have? And what am I exposed to and aware of around the company that I can add value to? And when employees understand that, they really feel like they have a stake in the game. And I say employees, not just limited to engineers, marketing people, sales people. I mean, you would be surprised when you open up your culture of innovation and the freedom around the company, what type of great ideas that will come from people who are maybe not hired to innovate your products or design or build your products. Often you'll get these just from people who just have an imagination, who maybe just even this frustrated inventor or entrepreneur who can help this company and really add value. And intellectual property are, the manifestations of these different ideas. Also being aware of the company's IP. When a company in its normal course of business is doing things like negotiations, joint developments, mergers and acquisition, you really need to be aware of what intellectual property the company has. So for example, if a person is going into a negotiation and they're going to be licensing different types of IP, it could be generally stated in the contracts they're working on, but it's really important that they understand what IP is relevant to this transaction. Is it a certain number of patents? Are they particular patents? Is it something copyrightable? Is it open source code? Is it your brand? Is it trademarks, right? All of these things are intellectual property. And in many contracts, sometimes they're conflated. They just talk generally about IP. And patents and trademarks, copyrights, open source trade secrets, these things are very different in nature. They're cared for differently. They're protected differently. And often they can be overexposed in negotiations where it's not necessary to expose them at all, right? We'll get into that a little bit more. Visibility is very important, and auditing and having a structure to your IP gives you, the in-house counsel, visibility and enables you to report up to management and anybody else who needs to understand the IP to report to them in a very clear manner what IP you have, what IP is at risk or subject of a particular transaction or a person's day-to-day job. And it's your job to really have this visibility, your own reporting and recording, so that you can have access to the IP and just know what it is. Often when I start with companies, big and small, they're not fully aware of really what the key intellectual property is, especially when you have founders that have moved up into management and you have innovators who are now implementing the products and they're going on about their business and introducing new products. Often there's a disconnect in understanding and visibility of specific intellectual property. And it's really good to have this central recording and reporting system so that if anybody really needs to know, it's at their fingertips and easily managed so they can understand what IP they need to be aware of. Also, culture of innovation. Again, I didn't mention this before, but it's like this holistic approach, right? One thing that I really emphasize with all clients is that you don't want to be myopic about your intellectual property protection. File patents for every technical innovation, file copyrights for every software code or any type of expression or marketing things, right? Sales things, website things, right? You really want to be judicious on what you're protecting, and you want to understand why you're protecting it. How does it affect your products in your company? And then you can make some real choice decisions on how to protect these things. For example, filing something as a patent exposes it eventually, because in 18 months or when a patent issues, it gets published. This thing that is described can be published. So you don't want to include trade secrets in there if it's not necessary, because otherwise you wouldn't have them exposed. Negotiations where there might be trade secrets that are affected in the transactions among an outside entity, customer, vendor, or some other partner, you may not need to expose those trade secrets. So you want to be aware of what those things are so that when these conversations happen, things don't slip out. Things that are not necessary for the transaction do not need to be exposed, because with trade secrets, their value is in their secrecy. And once you've exposed them, they're no longer secret and you don't have control over them. And contracts can only do so much to contain any kind of exposure if it wasn't intended. Guidance by outside counsel and certainly in-house experts, which I truly believe each one of you can become, right? Understanding your IP and understanding how it is protected. You can give guidance even though you're not the one who's the outside expert and actually doing the filings of your patents and trademarks and copyrights. Proactive attitude. Very important to be proactive, because no one's going to do this for you. It's not something that naturally happens. In fact, the person who handles the IP is necessarily in the rear with the gear. The companies, the innovators, the salespeople, the engineers, the management, they're moving the company forward. They're steering the ship. They're selling products. They're creating products. But they may not be looking over their shoulder and saying, hey, did we patent that thing? Did we protect that? Is that trade secret well contained? Did we file that trademark before we did our launch of the product, right? So you need to be really proactive and aware and have a system in place, have a strategy in place, and an IP program, a stated IP program that has checklists and things that will help you understand when these different events happen, when you're doing a new release of your software, you're releasing a new product, hardware or software, or you're doing some kind of marketing campaign, that you have these things well taken care of, right? Because the engineers are not going to do it for you. The product people won't. You need to have these in place so it's so easy. So like before they release a product, for example, there is this flag that goes up, checklist is here. Hey, before you release the product, let's see if we got anything patentable to file. Let's make sure that we contain our trade secrets. Don't expose this stuff, right? And overall, wise financial restraint. No, every company has lost their sense of humor for high legal spend, and you often don't need to spend too much for your protection. And you want to be really aware of your IP so that you have the appropriate protection and that you have, the financial understanding of everything, what it costs, both when you initiate intellectual property protections and in the future when you have things like maintenance fees, maintaining these things with ongoing costs. Protecting valuable ideas. So part of this is, and we'll get into the auditing, we'll get into the structure. I want to go over a little bit of this first because I want to really help you understand and heighten your awareness of intellectual property, what it could be, what your company's intellectual property could be, what could be hidden, what could be better handled. And then we'll talk about, how to audit, see what you've got, right? So a strategic plan with structure and budget in place, you want to focus on the things that you want to keep exclusive or monetize. And it's not every single thing. If you were after every single trade secret your company had, it would be like boiling the ocean. I could fill my office full of golf balls to the ceiling if we considered every single trade secret a company had. But you just want to be reasonable and look at the key things, the trade secrets, the technology, the things you want to patent, the things that are going to be exposed anyway when you sell your product, considering whether or not you want to have exclusive use of this, whether you want to have patents that show to the outside world how protected you are and causing your competitors and any new entrants into your market to take pause before they knock you off, right? Again, no one will do this for you. And the internal experts, the legal officers are the ones who really need to take the lead. And this is probably the highest value you can give a company in the legal department, aside from all the other important things, employment, corporate structure. But the intellectual property, the assets are extremely valuable. And it takes, frankly, a modest investment to set up a program, some investment in time, and a modest investment in fees and costs to set up a proper IP protection program so that your company has these valuable assets and they're protected. So Shai, I think you're going to launch a poll here. There you go. Does your company have an IP strategy? Let's talk about the numbers real quick, though. So 40%, 66 people, and not everybody has chimed in yet. They do have an IP strategy, and 13% do not, and some are working on it. And it's great to see working on it too, because frankly, you should always be working on it, right? You should updating it, refreshing it, reflecting on it, and seeing how does your IP strategy, how does it fit your company? How does it align with the business strategy, management's business strategy? So kudos to you working on it. It should always be a work in progress. There's always room for improvement. And hopefully I can help you with some ideas here to improve your system as you're building it. Purpose of IP, leveraging IP to lead markets, the third pillar, right? I mean, why do you have IP? Why do you protect? Why do you file patents, copyrights, trademarks? Why do you maintain trade secrets? Deterrent against lawsuits. There's this old adage of on the police side of police in my family that the high police visibility is the best deterrent against crime, right? It's an old adage. And high visibility of intellectual property is a great deterrent against lawsuits, certainly by practicing entities, and even patent trolls and whatever you want to call them, companies that are asserting patents. If you're savvy, you have a serious patent portfolio, then they're going to know that you're ready for a fight, whether you're going to countersue against someone suing you for patents, or you're going to beat up on a patent troll who's trying to, leverage their patents and get licensing fees for some kind of settlement. Having this type of asset and this very clear, outwardly visible patent strategy that they can see through your patents and other activity will make them take pause before they come after you, certainly coming after you first. Because like any kind of bully, they're always trying to go for the easy fight. They really want to get an easy take and show that you're not easy with this intellectual property strategy. Show that you're serious, that you mean business. It gives you credibility in your industry. It can give you licensing revenue, exclusive use of technology. These are the things that you leverage your IP on. Leveraging in negotiation, business negotiations and contracts. And this is most often, I think, where the rubber hits the road for intellectual property. Because when you're negotiating, when you're in business negotiations, you're talking to partners and even customers, right? Or if you're a customer dealing with a vendor who's selling you a product, having intellectual property can be extremely valuable for you. And I'd like to give one example of this. There's a company that was an energy company in Europe that was looking for a vendor to build a software system for them to read a bunch of meters, 40 million to be exact, and to read them every 15 minutes and bubble up the data, right? And it's not, it's a big task, but it's been done before in many ways. So anyway, this vendor offered to build this for them, and they filed a bunch of patents on it. So now this company has this system. It's integrated in their product system, in their energy system. And now they don't have so much, or they feel like they don't have as much freedom to choose another vendor. They don't have freedom to operate with respect to choosing other vendors, maybe better vendors. They feel kind of trapped, right? Another way to approach that as the customer, the big company, is lay out the blueprint of what you want to build. Get some consultants in, or get your smart engineers inside, or get some university professors to help out. You can pull a lot of ideas together. You can innovate with intellectual property, file lots of patents, and then you reach out to vendors. Because really what patents are all about are their solutions to problems. And the problem, for example, a problem statement would be that they want to read all these meters and they want to have a system that bubbles up the data, right? The better you define the problem statement, the easier it is to get solutions. So you put a problem statement detailed in front of engineers, they'll solve those problems. They will come up with technical solutions that meet those goals. If you just throw up this general description of what you want to do to a vendor, they are going to do that. They are going to pull together this detailed problem statement, this work order, and they're going to build this thing. And with all of those solutions, they're going to file patents on this thing. The more that you can protect on your side, the better off you are, because now you have more freedom to operate. In fact, to the extreme, you would almost be contracting a software developer to build something on demand for you and not innovate anything. All you need to do is code it, right? So there's an extreme case. In fact, in this case, this vendor built a really big startup company, and they took the same system and they sold it to this company's competitor. Now, this company wasn't expecting that, a little bit naive, but they built this system that they can just sell to anybody. Now, if the company had innovated to start with, in more detail laid out the problem statement, filed some patents, they might have some say-so as to whether their competitor can get this product. If nothing else, maybe they can get exclusive use for a number of years before this thing can be sold to other companies. So it's an example of leveraging IP to lead markets. I mean, this company had this idea and this decent problem statement to improve its business, and they didn't expect it to go to their competitors. They should have gotten an advantage over it, at least a time advantage, to have it earlier. So there's an example of how you can leverage in business negotiations and contracts so that you can use your IP to better your position and better your company. Collateral for loans. Now, this is this is a new area, very fast growing area, where there are financial institutions, particularly in New York, that are giving loans to companies, both startup and big companies, based on their intellectual property. In a bigger sense, a company like Ford Motor Company, right? So if they want to build a new factory for electric cars and they need to borrow, $10 billion, they go to the World Bank, and one thing the World Bank looks at is this long history of filing patents. And it is significant because they want to know that this company is going to be around to pay this $10 billion back. And, a company like Ford Motor Company, they file thousands of patents per year. It's a larger scale, but it's the same basic concept. And now, financial institutions are looking more to even startup companies before they even have products, giving them loans, because they look at these companies and they see this innovation. They see this the ability to exclusively use technology, and they see that these companies will likely be around in the future to pay back these loans. So you can leverage your intellectual property collateral for loans. Probably a great subject even for a separate talk. So visibility starts with an audit. By the way, if you do have questions, feel free to put them in the chat, and Shai will interrupt me if there's something relevant to what I'm talking about, and unless I'm going to talk about it shortly after. But still, ring in with your questions. I'm happy to answer them. There'll be questions and answers afterward, right? So you want visibility with your patents, trademarks, copyrights, and your trade secrets, right? And that starts with recording, certainly with auditing, and just exploring and triaging your company, triaging the technology, triaging, all of the different types of notes and ideas, problem statements, and different things that from marketing, sales, engineering, and putting them in the different categories. Now, patents, trademarks, and copyrights are ways of recording and certifying intellectual property, right? Registering trademarks, issuing patents, registering copyrights. Now, you don't necessarily have to, do these registrations for every single, intellectual property in your company, but these are the tools that you use to leverage things for exclusive use when it's beneficial to the company. It usually starts with trade secrets, right? Because every idea starts as a trade secret. Every single new innovation or idea of a company starts as a trade secret. It's in your head, and you share it. And from that point on, it ends up going down this path of it's either forgotten, it's recorded, it's used in a product, it's used in a marketing campaign, it may be described in a patent application. So it starts as a trade secret. And so when you're triaging this, you want to talk to the different people in the company and understand, what is it that we build here? What is the technology? And what are these novel nuggets out there that we've done that's never been done before? And identify them in the different categories. So trademarks, right? These seem pretty straightforward, but trademarks are geographic, and they can be registered or they cannot be registered. If you don't register your trademarks, but you use your marks, whether it's a logo or a word mark, you use it as a trademark, you have common law trademark rights. And you may want to go to the extent of registering your trademark, but you might not. Some things like slogans and things, right? You might register them to hang them up, or if you expect to use them long term, but often slogans have a shelf life. And by the time you get a trademark issued, you might be done using this slogan. So you might not register every single thing, and you don't want to overspend if it's not necessary. But you want to be aware of, what are the trademarks that you're using? What in your company, what identifies your company? The source of your goods or services. That's the purpose of a trademark. What identifies your company as the source of these goods or services? What do people think about when they think of your company? Is it that logo? Is it that word? Is it that phrase? Is it a person, right? Is it the way your product is shaped? You want to be aware of this. And the only way to do that is to ask. Talk to marketing, talk to sales. What are the things that ring when you're looking at customers or even competitors or other people? What do they see you as, right? And you want to understand, what are these things? And are they registered? Should they be registered? Make a long list of assets. Make an exhaustive list of every single thing that you have, trademarks, for example, things that you're planning to use, and lay out your strategy. Are we going to register these things? Should we register these things? Are they registered, right? These are the initial questions. You want to boil these up so you see them all, and then you can sit back and talk to some people and understand what things are so valuable, what's really valuable to us, right? And how are you monitoring your trademark assets? Unlike a lot of other assets, trademarks, they're based on use. Their value is based on the use. And if you want exclusive use of any trademarks, you need to monitor and make sure that no one else is using them. Because if you don't pay attention and other people start using your marks in different ways, they can become generic. Or you just have someone who's just using it and they're causing confusion out in the marketplace. So, and remember, trademarks, the purpose of trademarks is to avoid confusion in customers, in consumers. That's the overlying purpose of trademarks, right? It's an asset of yours. It's valuable and all those things. But the purpose of a trademark is to avoid confusion. And the only way to avoid confusion is to monitor your trademarks and make sure there's no confusion going on. Make sure there's no other uses of this thing. Things like Kleenex and even Google for that matter, right? These are terms, get me a Kleenex. That's a trademark brand, right? But people refer to Kleenex as any brand of tissues and things. Let's go Google that. But once you Google that concept and see what's out there, right? As much as they defend their trademark, and it's pretty well defended, it is always at risk of becoming generic because it is this functional thing. So you want to understand your trademarks, you want to monitor them, are they registered, and triage them and see what you're using. Copyrights, again, how are they registered? What is copyrightable material in your company? Do you have some ornate things, whether it's on your documents or your website or your product itself? Is it copyrightable? Do they recognize something in your marketing that is artistic and they see it and they think, oh, your company? Kind of like when Apple is going through that campaign and you see Einstein, think different type of thing, right? And although Einstein is a person, he is something that they obviously licensed this image, and people, when they see it, they're like, oh, that must be the next Apple thing, right? So these are things that you need to be aware of and understand so that you can protect it, so you don't lose use of these valuable things that identify your company. How are copyrights registered? What is your software development? What are the processes and how do your software engineers develop their products, right? Do they use open source? Now, we did a talk earlier this year on open source, and it's a whole big bag of worms. It is a copyrightable thing. Source code, your computer code can be protected with copyrights. You need to be aware of that. And if you're involved in open source, or if you open source your code, you open source your code with restrictions of use. So in order to enforce those restrictions of use, you need to copyright, register your software so that if someone is misusing your software, some other company being knocked off, they're making unauthorized copies, you want to have the copyrights registered so that you can enforce those rights. Patents. Now, patents, that's my thing, right? And we also do copyrights and trademarks, but patents are much more complicated. Unlike trademarks and copyrights, patents give you a right to exclude others from using it, right? Trademarks and copyrights give you a right to use. You can also enforce them and exclude others from using it, but patents are focused on excluding others from using your technology. They are functional in nature. Many of them describe structure. You have structural claims, you have descriptions of structure, but in the end, patents cover function and how your product functions. Now, these are utility patents. Design patents are about aesthetics. They're about, the look and feel and the recognition, kind of like a trademark, right? And if you look at the patent application for a design patent, it's ornate. It's just a number of drawings and a couple of sentences. Utility patents tell a story. They describe the function, flow charts, architectural diagrams. For physical products, there are blueprints and cutaway figures and different things. So for patents, when you're auditing your patent portfolio, first you want to look at what have you filed. Looking at your product, what is your product? How does it function? And what does your product do that's never been done before, or that's just not done by other competitors? These are the things that you look at when you're identifying possible patentable subject matter. So at a high level, you really just need two things for a patent. It needs to be new and it needs to be useful. And other patent attorneys will tell you it needs to be non-obvious, which is true. But when you're triaging, you want to set out a broad net. Look at anything in your company that's new, that you believe has never been done before your company did it. And how is it useful? The useful thing is usually the easy thing to figure out. Here's a certain function that is, unique to our product and our customers love this, right? And you get those answers from not just engineers, but sales, marketing, again, what really rings with your customers. Pay attention to that. Those are the key intellectual property that you want to focus on. But you could have lots of other functions and operations and things your products do, processes for making your product, different things, right? Even delivery systems. Look at all of those things and see where would management like to have a potential choke point where they could stop competitors from attempting to do what you do and what you do better and what you do uniquely. So you want to get a long list, a long triage. And I'll tell you what it looks like. It's a spreadsheet of lots of things that you list that are functionally unique. You want the same thing for trademarks. You want it for copyrights and status and how you use them. You can fill out your spreadsheet, right? For patents, you want to focus on, since there's a lifeline for these things. You want to look at the features, functions, and things in your products that are unique, and you want to list them. And that due diligence list, or your product, your reporting and recording list, looks like an Excel spreadsheet. Maybe there's a serial number that you come up with, P1, P2, P3, on and on, right? And you may want to call them disclosures. So D1, D2, D3. And you list all of these things, and these are functional assets, and they're trade secrets unless they're filed as patents, right? But you list them all in the same list, every single one of them, every single function, every single thing that makes your product unique. And you want to also list the inventor who created this thing. There could be numbers of inventors that created this functional process or this device or this product, right? Then you have the status. Did we file a patent? Is this thing a trade secret? Is it possible to keep as a trade secret? Is this in our product, and is the world seeing this feature? Whatever the feature is, even after you release the product, you sell this thing, you disclose it to the public. In the United States, you have 12 months to file a patent application. So you want to do the triage back even 2 years and make sure that you are kind of boiling up every new idea that you have if you haven't done that on a regular basis. And you want to understand, is this thing patentable? And then you want to make the decision, do we want to file patents? Here's the cost, here's our budget, and here's how important this thing is. So there's your decision point. Now, if you decide that you can keep it secret, and it is kept secret, and you're using it, and it's useful, or you will be using it, you keep it on the list, and this is your recording of your trade secrets. Move it over to the column of filed patents. Eventually, it's not going to be a trade secret anymore because it will be published. So functionally, this is something that's really important to do. And if you walk away with one thing from our discussion today, remember, this is a good system for recording your trade secrets. You need to do that. And to triage your whole portfolio and have a date-stamped record of your trade secrets. And if you just have that, then this exercise was worth going through. Not many companies do it. Not many companies record their trade secrets. And I'll give you an example. A company that you probably know very well, Palantir, they're in artificial intelligence and lots of government work and all these different things, right? They were growing, they weren't public yet. There was an investor, a board member who was inside their company, had a very cozy place, had a desk where everybody was working, and he was hearing all these ideas that were going around. Well, there was this concept that came across that they figured they would use in their roadmap further down the line. And he heard it and he took notes on it. And you're not going to believe this. I found it hard to believe when I heard it. This original investor, board member, cozy friend and ally of this company filed a patent application in his name, in his own name, did it all by himself, didn't tell the company. Well, guess when the company found out? When the patent published. The patent published, they saw it, they saw his name, they couldn't believe how betrayed they were, and they not only kicked him off the board and out of their business, they sued him for trade secret misappropriation, right? So all that drama aside, fast forward to a hearing that they had in Washington, D.C. in front of this judge. They're suing this guy for trade secret misappropriation, stealing trade secrets, right? Of course, they lawyered up on both sides. This guy has to defend himself, it's his reputation, and the company, for some reason, really wanted to put a lot of effort into beating this guy up. They're in front of this judge, and the judge said, okay, show me evidence that you had possession of this trade secret before you say that he stole it. You need to have that. Now, you can do that with testimony. You can say, I owned it, this and that. If you have a date stamped example, even an abstract, an email, something, you could show this to the judge and say, listen, we had this before. We discussed it in several meetings. It was in our roadmap. It's just not in our product yet. Here is when he filed the patent application, he stole it. They didn't have that. They didn't have much of anything. So you lose in the United States. There's other ways you can take care of this in other countries, but there's your trade secret problem, right? And you can solve that problem when you're dealing with patents. You just list your trade secrets because you don't register them. It's a funny thing about trade secrets. You don't file a trade secret registration application with the US Trade Secret Office. It doesn't exist. It doesn't exist. But using different types of programs internally, or some commercial programs, you can take these ideas, these trade secrets, and record them internally and date stamp them. Outside attorneys can do it too. I have clients that we keep up these due diligence lists. You could use Google Docs and different things where you've got a date stamped recording of your idea of this concept of this invention. Put it in your spreadsheet. You can even attach drawings, flowcharts. You can have everything that you put into a patent application, but you don't have to file a patent application. Keep it in your records as a trade secret. You've got a registered trade secret, right? Voila. So focus on the points of enduring value when you're really focusing on, whether you're going to consider filing things for patents. Organic inventions that you create internally. You want to look at, competitor roadmaps. In your triage, you might come up with new intellectual property, new applications of your inventions in your competitors' products. Now, every patent application that I write and that all the attorneys in my firm write, we always talk to the client about who are your competitors? Who would likely knock this off? Who are you up against? And they'll come up with a list of companies. And we challenge them, okay, if this competitor was going to use your product, was going to use this feature that we're patenting, how would they do it? Often it's a little bit different because every company has its own system, its own product, its own thing. But if you describe it in your patent application and you file claims that cover your competitor's likely use of your invention, that makes it much more valuable. Because if they make some changes that are outside the invention that you claim or that you get issued as a patent, then they're not going to be infringing your patent because they might do something different than what you're doing, and they may have even invented their own way of doing it. But if you at least consciously think about your competitors, your customers, and even your customers' competitors, you can enhance your patent application. It's a modest investment. You're adding a few figures and maybe a few pages of description, and you're covering this thing much more broadly. Keeping in mind, the most valuable patents are the patents that other people infringe, right? It's not just the stuff that you use. If you're patenting something that only your company would use or could use, it's much less valuable than if you had inventions, patents that covered things on your roadmap of your competitors. It's perverse, but the patents that you have, you want infringers. Those make the most valuable patents for monetization, defense, etc. Trade secrets. So we went over trade secrets. It's I was getting a little ahead of myself. But trade secrets are extremely valuable, and it's something you can get from this triage. I mean, when you're doing an audit, everything's a trade secret if it has been published or sold in your product, disclosed. They call it a public divulgation. That's probably the only time in your life you'll ever use that word, divulgation, where you have divulged your invention. That is, a very clear, visible representation of your invention that the outside world can see and practice it themselves, white papers and such, right? Or your product. If your product can be reverse engineered, then that could be a public divulgation if it's in your product, aside from being sold and on sale bar, right? Once you sell your product, or once you divulge publicly the details of your invention, you lose all of your foreign filing rights. And on those dates, if you can ascertain them well, you have 12 months to file in the United States. So when you're doing your triage, you discover things that, oh, this is already in our product. Oh, we already we disclosed this at a conference, or we shared this with someone who's not under a non-disclosure agreement. You have 12 months from whenever that thing happened to file a trade, or to file a patent. So keeping that in mind, deadlines are very important to keep in mind, especially when you're doing triage, because you might find some last minute things where, hey, if you want to patent that thing, you better get moving and get this thing filed because you're under a deadline. So good thing to keep in mind when you're doing your triage, right? Structure. We talked a lot about auditing, right? And just so we wrap up auditing, practically the best way to audit is to try to pull whatever listed information that you have. And then what we often do with clients, we start with the engineering management, right? You want to talk to the people who understand generally what are the new things that's going on. Often the engineering managers do, maybe the CTO, depending on the size of your company, it might be a number of people that you talk to in different divisions to gather all of this information. And at a high level, you're going to understand, okay, this is the new stuff that's going on in the company, and this is the thing that really differentiates us, and these are the things that they're aware of, right? Then from there, you work your way down to, maybe the more senior engineers and other engineers, depending on, the scope that you really want to put this through. And you get an idea of all of the possible new innovations, what's new, what's useful, all of those things, exhaustive list, talk to the people, find out, where these things are. Because often you can't just go to your wiki site or your database. You're not going to find everything, because company records, unless you deliberately do so, you're not going to have descriptions of all your inventions, descriptions of all your trade secrets. You need to talk to people and understand, what are these things? What do we have? Oh yeah, this has been secret. We've been keeping this secret. We don't tell anybody about it. Did you record it? No. Okay. Now we got a process for recording it. We need you to describe this. We need you to explain this to us. Give us some drawings. Give us some explanation so that we record it. We'll consider filing a patent for it. But now it's in the system, right? Unless you ask about it, unless you really do a survey and talk to people, then it's not going to make it in. And it could end up being the secret that's vulnerable for loss because it's out there and it's not made protectable, right?
Hey, Dave, so I launched the second poll.
Yep, I see it.
To be from before, but we have some interesting results if you want to go over it.
Yeah. I like that some have had their IP assets audited. Often it's a very unique idea because Usually when a IP program is put into place, it's not necessarily audited. And what is an audit? We were talking about what an audit is, right? Often what happens, in fact, so I was working with a client not long ago. It was a satellite company. And it was very clear they only had a few patents filed, right? And they had all of this innovation about, networks in the skies and all these things, but they only filed patents on these trivial things like mechanical things on the satellites and things, right? And it was kind of curious what, how they came about all this. It turns out that much of it was the CTO didn't believe in patents. And I'll share, it's kind of funny. We were interviewing him and we were interviewing the engineers and everything. And before we even started the conversation, he said, listen, I just want you guys to know, I know you're patent attorneys and everything, and I know we're doing here, but I think patents are a bunch of BS, and I don't believe we should file any of them. Well, that told me they probably didn't have a whole lot of protection, because at the very top, they didn't have belief in a system, and they didn't believe that patents were valuable or IP was patentable. Well, in our conversation, before we even met with them, we did some searching, and we found a very large company that had a huge suite of patents that they acquired from another company that reads on pretty much everything that they plan to do. And by the end of that conversation, the guy was crazy to file more patents, right? So it really is about awareness and understanding what are patents, what are trade secrets, what are they used for, and are they valuable to your business? In this case, they had a huge threat waiting out there that they were not even aware of. They didn't even look, didn't even know. So being aware of these things, I mean, their patents, the only ones they filed, from what I could tell, was an opportunistic inventor that said, hey, I want to file a patent. I get my little bonus and I get my name on a patent. Isn't that wonderful, right? But that's what was driving the patent program. They had maybe less than a dozen patents, and they didn't cover anything that was really, key to any of their business or products. So auditing can be, it doesn't have to be this big expensive endeavor. When we help clients do it, it just takes really a few hours, because what we're doing is we're handing over our checklists and asking these questions that they usually take and work on internally, right? You build the system up, and it's frankly a modest investment of time. It doesn't cost a lot of money, even if we would help you or someone else would help you. But getting that awareness is invaluable. Just understanding what you have, right? Most companies, I would have to say, fall right into the ad hoc, case-by-case basis, right? They understand patents are valuable. They kind of know what's key. They file patents on things that they think are important. And case by case, they're like, okay, we're going to look at what we have here and make sure we're covered, right? And that's 36% of the poll here. The ones that don't have an audit, reach out to me. I'm happy to give you even free checklists and things to get you started. Hopefully this talk will get you started in at least triaging and starting your audit. Okay, so let's let this poll roll, but I want to also just say the last couple of things on structure, right? I've been talking a lot about auditing. The structure is in the background of your audit, and the whole idea of a structure of your IP portfolio is to structure it so that you protect the things you want to protect, you want exclusive rights, and you don't protect the things that are either less important or the things that you're able to keep trade secret, right? So when you're looking at the audit and your structure, you want to look at things like competitors, follow their roadmaps and plant the risk there. So when you're looking around for stuff and you're finding these trade secrets and their patents, look at where you have an advantage over competitors and consider whether you want to file some IP protection in their roadmaps so that it protects you. Vendors, again, like the example I gave you, you could build an IP cache to use in negotiations. It's always better to do it early and before you interact with them, before you negotiate with them, and it gives you a great advantage. And it's also just very helpful. I mean, defining your own problem gets your solution, and nobody knows the problem like you do, and nobody knows your customers and what you need like you do. So there's no reason to just hand the whole thing over to your vendors. Define it a bit yourself. Even some of the technology, own some of it and just lay it out better. So when the product comes back to you, there's no surprises. It may even be better than what it would have been because you had more input. Products are always better with customer input. Joint development, of course, and this, I could do a whole talk on this, but you want to make sure that you seize the advantage of your superior intellectual property when you're jointly developing something. That vendor product is one example. You might have a joint product that you're putting together with even a competitor or some type of business partner. And the more intellectual property that you cover, the better off you are. You know, there's three categories. One, the things that your company invents, own all of that. There's the stuff that the other company invents, they own all of that. You want a license, right? But there's the stuff in between where it gets complicated, where you might have joint inventors from both sides. Figure out who owns that, right? And of course, the best scenario is that you own that IP, you give them a license, right? And there are many different ways of doing this. But in the business practice, it's good to educate the business operations people to understand, listen, invent as much as you can and own it, right? Try to stay away from the jointly developed stuff if you can, so that we don't have this messiness of joint ownership of technology. So keeping this in mind, M&A, of course, you know, preserving value in IP assets, looking at potential acquiring companies. Maybe your company wants to get acquired. Maybe Google or Oracle or a large company might want to acquire your company. It's wise to look at how they protect their things. You can protect things in a similar manner so that when you're on the block, when they are looking at possibly acquiring you, they're going to see what they like to see, what they're used to seeing, with the things that they're familiar with. And it can add great value when you actually do the acquisition. So the poll, does your company, goes to the next, let's see here. Next slide. Does your company set a budget for patent filings? Yes, no, open checkbook, others. So yeah, I mean, this is a really good thing. And it's not surprising, and it's actually good depending on the company, right? I mean, it's often difficult, especially for a startup company or companies where innovation kind of comes and goes. It's not always predictable, right? Where you're like, look, we just added all these new features. We launched an improved product. We're going to jack up our patent filings because we've got a bunch of inventions, right? We didn't file anything until, you know, July of this year, but we're about to launch in September. We're going to file like 30 patent applications. So up goes your budget, right? And you have to, it's difficult. The financial groups hate this, but often that's just how it works, right? And you have to make that decision. Look, do you want to make this investment? Because you probably want to file it before you launch your product to preserve your foreign rights. You want to file patents as soon as you can, as soon as they're fully baked, so that you can get the earliest filing date prior to anybody else filing for your similar inventions, right? And you want to make sure that you're well protected. But you want to keep, you know, this dry powder, this reserve cash that's available to you, so that, you know, with approval by management and proper channels, you can say, listen, we want to invest in this IP, and we want to file in foreign countries too. And here's the projection based on all the inventions that the inventors gave us, right? So yeah, it's a great poll, by the way. It's really interesting to see this. It's almost equally between yes and no as the budgets go. Larger companies, of course, have budgets because there's more of a flow. You know, they could file hundreds per month throughout 12 months, or at least, you know, even 30 or 40 per month. It's pretty steady because they have a program that's constantly feeding in new innovations. And the larger a company is, the more products they have, the more engineers they have more of a flow of new ideas and innovations that are going into improving their products. Makes it more predictable. When it's not predictable, difficult to have a budget. We'll be talking about budgets in later webinars. Reach out with any questions directly if you have these. Budgeting is super important. Management hates surprises, especially with intellectual property costs, because they're high. And it's good to keep this visible. Patent costs, here's a slide. This is just an example. Pretty accurate one, I think. You know, getting on file in the United States is about $10,000. Getting a patent issued, it's a big range, as you can see. It's pretty wild, but it really depends on competent patent counsel, how to keep that spend down and to get good patents issued, right? We're definitely on the lower end of those things because we're extremely proactive with examiners, and it makes a big difference in getting patents issued timely and less expensively, right? The more time it takes, the more you're paying attorney time. You should not be spending more than you need to. Maintenance annuities, these are annuities in the United States every 3.5 years. Foreign filings, very different. Foreign filing, you pick from a list of countries, 185 countries. Usually there's a subset. For hardware, for example, you would go with possibly Korea, China, Japan, Europe, and the United States. Medical devices, you'd throw in Australia, because that's where a lot of medical devices are, they have quick adoption, different things. Depending on the company, depending on your product, there's different lists of foreign countries that you choose. From the list I just gave you from the hardware example, getting on file in foreign countries is roughly 20K, and foreign annuities can be around 10 grand per year. Thanks for moving that to the other slide, by the way. I can see it now. And as another example, here's a yearly budget projection, right? So move this poll. This is an example of between 30 to 40 patent assets, right? Filed 10 applications in February, foreign filed 5 applications from last year. So this is an example of a company where you have this flow. It's been a couple of years, you started filing patents, and this is your run rate right now. You're going to file 30 or 40 patent applications. You have this many assets pending, and these are the various costs, right? So you typically have some portion of, new patent filings, foreign filings, costs for foreign filings. Those are usually fees, translations, where like our firm hires a firm in a foreign country, Korea, China, Japan, somewhere, and they send us their invoices and fees for their filing. I mean, we file the applications usually in the United States first, and we just send a copy to them. They translate it, pay fees, do what they need to do, and it gets on file in those foreign countries. These are the relative costs. Responses to office actions, annuities in the United States. This is a pretty accurate example. In fact, this was taken from 30 of our clients that are kind of in the flow of filing patents, and this is the typical cost. So there's your budget for that number of assets, a pretty modest portfolio, about $215,000. And as you learn and review and understand your IP portfolio, you can adjust this accordingly. And of course, finance department can have a spreadsheet over what are these costs. And as the IP expert, you can help predict and project the costs going forward based on the properties that you're dealing with. It's all about the people. So I don't want to underestimate this. The question is, does your company have recognition awards for patent submissions, right? Yes, no, or do they just say thank you, right? And many companies do that. A lot of startups do anyway, because often the employees are getting equity in the startup. They have stock, and that's really their reward for being part of the startup. But companies that are more established that may not have generous stock awards, they want to encourage participation so when they submit an invention disclosure, they get a little something. If they help a patent attorney file a patents application, they get something more. And for for retaining good employees, you give them another bonus for when the patent issues. So they stuck around long enough for the patent to be realized, and it's integrated into the product. Valuable employees, right? Important. They've created valuable intellectual property. Everybody sees it. They all realize their own benefit from it, and it really invigorates engineers. And I'm going to there's a story I might have shared, I think, with an earlier webinar that I did earlier this year about inclusion and about recognition, right? And it's something you really can't underestimate, and it's an excellent and valuable management tool. And as the IP experts, to hand this to management, to be able to give this amazing recognition is extremely valuable. There was a client that I had years ago. It was a hardware client. Most of them were Taiwan-based. Many of them transferred over here. So it was like a foreign managed company. And there was a young woman who was a software engineer, hardware engineer, kind of both. And they were making sound cards, right? So it was the kind of thing that would go into your PC that was used in your gaming or music for sound and different things. Well, she came up with this really great innovation for audio video synchronization. And it was a problem that they really had a hard time solving. It's not a trivial problem. Audio is separate from video, and it's very difficult to integrate this into a product and make the experience unified. So like you've seen this probably in old systems where you watch a show and the mouths don't match the words that are being said, right? It's not a trivial solution to fix that. Well, she did. She made a really groundbreaking thing. She was one of very few women in this company, very young lady, but a brilliant person who came up with these innovations. At the end of every month, there was an all hands, the CEO would call. And one thing that he did, which I thought was brilliant, was to hand the patent awards, the check, the certificate, the plaque. He would have a list of engineers, inventors, and he would go through them and personally hand them the plaque, the check, whatever the award was, and describe generally what they invented and thank them, shake their hand. I mean, here is the CEO of this big company smiling on this person who's usually quietly in some cubicle somewhere and feels unnoticed, right? Like many of us do often, right? Especially this person, because she really was she always felt out of place being young and being, one of the only women in the company. So I told him about this thing that she did, and the patent actually issued. So she had been there for a couple of years, and the product had just come out, and it was like groundbreaking. It was like a big deal, right? And she was working on her next project. So anyway, she gets called up, and he saved her for last and gave out the other awards. She was surprised. In fact, he asked me not to tell her that the patent was allowed. He wanted to surprise her, right? So he went and shook her hand. This guy was 6'2". She couldn't have been 5 feet tall, shy, right? And he handed her the check and the plaque and shook her hand and held on and didn't let go because she was about to turn and walk away in all of her shyness. And she said, listen, he said, listen, I understand what you did. He had a microphone. The whole world is hearing this thing from this company. He said, I realize what you did. I know it was hard. And what you did really made a difference in our product. Thank you, right? And she just started crying and hugged him. It was such a moment, such a moment. And she was so invigorated by this. Well, I mean, she just continued to be this brilliant engineer. She moved on to bigger companies, right? Someone who recognized her even more. And now she is this groundbreaking engineer, a brilliant, and she ended up getting her PhD with all of this motivation, all of this encouragement. And it changed her entire career. It changed how she was recognized in the company. So the point is, it's all about the people, and the recognition is it's equal to any other benefit or value that intellectual property gives the company, is motivating teams, motivating individuals, and rewarding them. The recognition alone is incredibly invaluable. So keep that in mind. When you do your triage, when you do your audit, you're going to come up with all kinds of new things. You might not file them as patents. You might not get that kind of public recognition, but the company can take these different, ideas, concepts, these novel approaches of doing things, recognizing these employees, and it can have an amazing effect. And many companies often, like many times, you'll see the founders and such, these elite engineers that do all the patent filings. That should be discouraged, because many of the valuable innovations, patents and otherwise, come usually at the implementation level when you're releasing products. You've got many engineers working on these things. Founders do not have monopolies on all the ideas, even though they're founders. It's really important to get at least recognition down to the levels of all the people who are working, and even filing patents, because often those are the most valuable inventions, because they've got the customer input, the product's going out, and these are the finishing touches that make your product possible. Good to keep in mind when you're doing your audit and when you're doing your triage. And the poll. Do you have recognition awards? No. Change that. Even if you're a startup. Recognitions are huge. recognitions are really big. Plaques are inexpensive and they pay dividends, right? It's a constant reminder of this awesome thing the innovator did, right? And if you have no awards, there's probably might be a reason why. It doesn't take very much. It's not necessarily this big bonus that a lot of companies pay them. It's at least some token reward, whether it's submitting an invention or getting a patent issued. It also helps us as patent attorneys get our job done. So if there's a bonus waiting for them when we file our patent application, often they're more cooperative because they want that extra award. They're going to get paid for that and they feel good about it. So it also helps your process of getting patents, getting patents and such filed. Yeah. And that's all I got, Shai.
Brett, thank you so much again for another wonderful presentation. I have a number of great questions to ask. The first question I want to ask, many people have, it's actually a request. It's not a question, it's a request. People want the audit checklist that you distribute to your clients. So I told them to email Sabrina. Poor Sabrina's inbox is flooded now, but email Sabrina and we will, deliver the audit, not paperwork, but the audit checklist to them. So so you're okay to do that?
No problem at all. No problem at all. And I'll give it a sample Excel spreadsheet that has the columns of things you want to know about a disclosure invention. I'll make up a generic one so that you can see it and you can model it.
That's amazing. All right, awesome. So, okay, so that's good. I'm glad. Otherwise, we would have a riot on our hands, and luckily, riot avoided. Okay, so let's get to some questions. First question: how do we explain to customers that we will license IP as part of a paid work product, but not necessarily provide the bottoms up tools which underpin the IP?
I understand the question. So a customer has hired you for a paid work product, right? Let's say that you are I'll make an assumption just for an example. If you are a software developing firm, contract developer, and you're delivering to a customer this product that they can use in their day-to-day business, and you have tools that enable this thing to work. They also enable the thing probably for maintenance, updates, new revisions, and different things, right? And this is an interesting, it's a product type of negotiation. And the answer to that is you get what you pay for, right? So in the one example of that vendor that delivered a product to that company, they delivered no tools. In fact, they got subscription for the maintenance going forward. So the customer doesn't do the maintenance themselves, and they're paying for that, not just for the contract for delivering that software product, but also for maintenance going forward, right? The tools that you're talking about, and I'll make a couple of assumptions, but let's talk about a couple different tools that you would have. Let's say that there is a custom tool. There's three different types. Let's say there's a custom tool that said, okay, we want the software to do this. We want this function. It's a shopping cart. It's gathering data from 40 million meters every 15 minutes and putting it into a database, whatever this thing is you're making, right? You had to custom make that thing because you needed to make this product work, right? But you built it. The software under your contract should, at the very least, of course, deliver the product for use by the customer. But it doesn't necessarily need to include those specific tools that were custom made for it. Are there other uses of these tools for other customers, unrelated products? And are they really asking for exclusive use of this thing that you built so that nobody else can use any part of it, right? Well, they're going to pay a lot more money for that, because if you're custom making something, you're sending off all the tools, they should pay more for that. There's a price for the product itself, the software thing, right? There's a price for tools. Now, for the tools that they described and broke down, like we were talking earlier, right? They got their experts together. They put together the blueprint. Here's the tool we want, because we want to be able to edit this thing in a certain way on an ongoing basis, and we want control of that. They'll pay for that, and they'll pay extra for that because it was custom only for them. The other set of tools, the third type, are the tools that you've been developing over the years before this customer even showed up, right? So if they want to use those tools, that's a completely different agreement, right? So I think what we're talking about is contract negotiations and who owns the intellectual property. It's all about the contract, right? So in a work for hire, you're getting paid and you're not going to get ongoing royalties. If they're taking this product and selling it to other customers, you're not going to get a piece of that if it's a work for hire, if it's a contract engagement, because that's what they get, right? Unless you do the maintenance. So I've broken it up into a bunch of different areas. So when you're talking about the underlying tools, the question is, who owns the intellectual property according to the contract? The stuff you already had is obviously yours. The stuff that you developed for them depends on your contract. You decide whether in that contract you negotiate whether you can keep it. The third type, if they're the ones who defined it and essentially developed it for you, then at least they put the effort in there. It's less of a research and development effort of yours, and they could possibly pay less to own those tools. So if I'd be happy to talk to you directly about the actual transaction, and we can probably unpack even a better solution for you, maybe a better answer based on your actual business.
Yeah, sounds good. Sounds good. What are the other considerations to consider when to patent something versus when to keep it as a trade secret?
Very good question. The number one question you want to ask, trade secret versus patent, it's not the budget one. Budget is always a question. How much do we want to spend? What are our limits? And we cut it off somewhere, right? But if you have, and software is a really good example, if you have trade secrets, an algorithm, an operation that you cannot see from the outside. So if your customer gets this thing, because one of your competitors will buy it and use it as a customer, can they tell what's really going on in the background? Can they really figure that thing out? Can they reverse engineer it? Can they tease your product and say, okay, well, how is this working? Kind of like dropping the ball in those little baskets and trying to predict what the outcome is, right? If they're not able to do that, your technology, that part of it's a trade secret. So you want to avoid including that in your patent application because you're disclosing something that can be kept secret. And often what you can do, let's say that particular function is part of an overall invention, you could genericize it, come up with a generic or just a different example. You don't have to show them your exact example or even the best example. You need an example so that it enables your system. So for a patent application, you have to describe how the thing works, but you have to give them examples so when you read the patent, you can actually make this thing and practice it, right? So for trade secrets, you want to avoid putting them in patent applications. We've had patent portfolios sent to us from very junior patent attorneys that wrote them and maybe even no supervision. We look at these things and they're full of trade secrets. Scary thing is when this thing publishes, they see all your trade secrets. So you want to cut it off there. So every single patent application you file, every invention you're moving from the trade secret column to we're going to file a patent column, you have to ask that question. It's the most important key question. Otherwise, it's a matter of budget and whether or not you want to get exclusive use, whether you want to patent it. If it's easily seen in your product, if you're going to publish it on your website or in a white paper, it's out there anyway. It's not a secret. So you decide whether you want to give it to the world for free or if you want to reserve the right of exclusive use by filing a patent application.
Can you use your invention disclosure process to capture ideas that were then evaluated to be best maintained as a trade secret?
Absolutely. Absolutely. And that's exactly what that spreadsheet is about. You'll see it. In the first column is a disclosure column. Inventor discloses to the company this thing. It's internal. Nobody sees this, right? And it's going to be a description. It'll be an abstract, maybe a couple sentences, maybe some drawings. Maybe you'll attach something, some technical documents. And there's your disclosure. It's a great place for a time-stamped invention disclosure, a time-stamped trade secret submission. So you don't have the Palantir problem, right? It's there. And if you move it to the file a patent column, it's no longer a trade secret. It's from a disclosure to P001. It's now a patent application. It's going to publish in 18 months or when the patent issues.
Gotcha. Any recommended cadence of IP portfolio review with key internal stakeholders? Is it quarterly? Is it, semi-annually, annually?
at least quarterly, right? Many times, so in software companies, once they get, if they have like a general product, they issue updates and different features. I usually get the call a month before they do the release. So it's whatever that cadence is, right? And that's usually when they're ready, because a month before they're like, okay, we're getting ready for this launch. We're kind of cleaning up the code, but they know what the inventions are. They know what the new features are. They know the function. So it's usually the worst time to deal with them too, because they're busy getting the product out, but they can get us the information we need before they launch it, right? Earlier, the better is always better. Putting it into monthly, quarterly, yearly, you could often, the problem is you often will miss these deadlines. You know, you'll end up with a product release, you'll sell your product and you lose your foreign rights, right? So if your company doesn't care about foreign rights, that's one thing. But if they either they care about foreign rights or they just don't know, it's best to preserve them before these events occur. It might happen, you know, January and then June and then August, then November, December. And that's because of the company events that could possibly trigger these deadlines. So you want to just be aware of those things. Try to look ahead as much as possible.
Can you talk about startups protecting and monetizing patents while still having, being underfunded or having no cash on hand?
Yes, there are lots of risks, and that's what they're concerned about. I know what this question is all about is, we've got these patents and we might have infringers. People have knocked us off and maybe we can monetize these things. Or if you're not necessarily asserting them or suing people, you might have this solution that you could license to a company that might not buy your products, but they might license it for their own products and approaching them. So first off, you definitely want to file all your patents ahead of time. You can even do provisional patent applications, which are less expensive. It's more work on the inventors than it is on the attorneys. You can do this inexpensively, but ultimately, if you're going to assert these things or somehow monetize them, you have to get patents, utility patents, non-provisionals filed. It takes time, but you can get these things issued, right? Now, if you're going to license these things or somehow assert them, you always need to expect that there could possibly be litigation. Because as soon as you, even in a friendly manner, you say, hey, take a look at this. It's awesome. Why don't you do it? If they're already practicing this or if they possibly infringe your claims, they can come after you for declaratory relief. Like, hey, they showed us their patents. They essentially threatened us. We're in federal court. I want a declaration that we don't infringe. Now you got a live patent suit. It can cost millions of dollars, right? One way to approach that, for example, if you have patents that you have infringers, let's say that the possible, impacted revenue and the possible royalties on your patents can be in the tens of millions of dollars. Now you're talking about something. This is something you can hire an attorney for to do it on a contingent basis or get litigation funding. You can get banks that will fund that litigation, right? You will likely want to set up your patents in a separate entity so that your company, if you're developing products, won't be at risk of the countersuit. So, so it's a broad question. There's a lot of ways of looking at it, but there are options. If your intellectual property is valuable and if you think you can monetize it, there are ways of approaching it to cut the risk of possibly ending up in a lawsuit and plummeting your company.
What about recognition programs for trade secrets? Inventors can get discouraged if patent application isn't filed, but a trade secret, can be even more valued. How do you recognize their efforts?
Right. Well, the different stages. It's a good question too, because there are a lot of companies where, also when economic times hit hard, may keep it as a trade secret because they want to cut their spend. If they're filing hundreds of patents and suddenly their revenue drops, they're going to want to cut that back and save hundreds of thousands of dollars. But you want to encourage the trade secrets coming in because you want to protect those. Trade secrets, it's just a spreadsheet, right? So there's not much to it. It's the least expensive way to protect your intellectual property. So you want to give them that bonus. Maybe it's a Starbucks card, or maybe it's a couple $100s, right? For submitting. And all of these invention disclosures are trade secrets until you file a patent. So they're all trade secrets. So you can pay them that bonus based on the disclosure, call it a trade secret, call it a disclosure. And then there's another bonus, let's say it's $1,000 typically for filing the patent application, where they help me file the patent application. That helps. And it's also an awesome bonus, right? And then the payment possibly when the patent issues. Another bonus you could pay is like, okay, here's your trade secret. The company is still benefiting from it, right? If this patent, in fact, Ford Motor Company has this long series of different awards that they do where if your patent that you file is licensed to other companies and it hits a certain level of revenue, you can get up to $50,000, your portion of that revenue. Let's say that they have a new like type of safety feature to the licensing to General Motors and Porsche and other companies, right? And they're getting revenue from these licenses. The inventor gets a bonus from that, and they're extremely generous. Look, you're making money off it. You're giving them a cut, right? You could do that as a trade secret or a patent. And if it's implemented into the product and it has to be kept secret, but it gives extreme value, you might give that extra bonus. Maybe that patent application filing bonus will be the implementation bonus of your trade secret. So there's different ways of doing it. It's all about recognition and giving a nod to these inventors, these innovators for coming up with something awesome that makes your business better.
Awesome. Next question, is there a format and process for the recordal process of trade secrets?
Well, just like I mentioned, the spreadsheet, getting submissions, right? And just like anything else, patent submissions or anything, you want to encourage when they come up with them, when they're fully baked, submit them, right? So submit them to this central person. And maybe it's one of the attorneys on the legal team where they have an invention disclosure form. They describe these things and it gets submitted. And it's in the D column, right? The disclosure column. And it's determined later whether or not it'll grow up and be a patent, right? So it's that kind of thing. So timing it's asynchronous, right? It just comes in as they come up with them. And they could send out reminders. Hey, got any new invention disclosures? We're looking for them. We're looking for, we want to beat our number last month. We had 40 last month. We want 60 this month. Submit your invention disclosures. And they get the little bonus for each one of them, right? It's all about incentives.
Got it. Do you have any software suggestions that keep track of IP, maintenance fees, perhaps trade secrets?
Yes, let's see. So these are docketing systems. These are IP management systems, right? Depending on the size of your company, you may or may not want to invest in such a thing, right? Ford Motor Company and British American Tobacco, they didn't like any of the systems out there. And I'll tell you, there is no perfect system, right? We work with ours and we produce reports for clients whenever they want them. Ford Motor Company and British American Tobacco created what's now an Aqua. They built it themselves. In fact, they even have their own employees that were like an Aqua fellows. They've been around for decades, and they're just experts at doing things like searching for patents and managing thousands of patents in their portfolio, right? It's expensive, extremely expensive. Smaller companies, you're better off. Get that window into your law firm's list, right? Or if you have multiple law firms, it makes it more complicated. But if you stick with one law firm, they can give you really great visibility, a dashboard of your IP. Because often we'll get questions from clients, how many patents are issued? How many applications did we file last month? There are these lists of things that belong in a spreadsheet, right? And every month or quarter, one of the management members might say, hey, do you have the latest status report? We get inquiries for those all the time. And it's a simple system. We just pop them off to them, right? Internally, you can get one of these systems. There's many to choose from, and it's really lots of pros and cons to them, and it really depends on how you're using them. You don't want to overspend on them, that's for sure. But when it comes to annuities and things like that, it's something that we do for our customers, for our clients. There are companies that only do annuities. And if you have a finance department, you don't need either of us. Nobody pays bills better than finance departments. If you've got deadlines for a maintenance fee in Japan for a patent and it's $1,300, you put it into their system, it's going to get paid, right? And it's easy to adopt all of those things because you know what the deadlines are. It's very clear. And the finance department can do it and can do it much cheaper too.
But one quick question, why not have something like DocuTrack where there's, and have a law firm do it?
Rather than have a law firm do it?
No, and have the law firm do it.
Sure, that's an option. Yeah. I mean, there's different systems we use for different clients, depending on their size, right? And depending on what they really need, right? Our startup clients, usually when they reach out to us is when they're raising money. Hey, we got to do a slide. We want to brag about our intellectual property, right? And we populate that slide for them, right? We take it from our system, we populate that slide, right? And DocuTrack is good. There's different things to use. The question to the client is, what works well for you? What do you like to do? If you like to get an email once a month, if you want a Google Doc that has all the stuff you need, populate that thing, great. I'd like to have access to that. Sure, we'll get that to you. And we'll refresh it every time something new happens, right? Many different ways of doing it. It really depends. There's no one answer because every company internally, they have their own things that they like. And there's nothing worse than dumping a docketing system on them that they have to deal with and that they have to understand and become an expert in, right? But we could do many different ways. So many approaches.
So two more questions, actually one comment and one last question. My suggestion for future, topic is best practice for patent labels for manufacturers. Well, what are patent labels for manufacturers exactly?
Right. So when you have patents if you have products that embody inventions that are patented, right? Patent pending, and you'll see often in different things, like you flip over some of these laptops or phones, you'll see covered by the following patents, right? Apple can't do that because they have tens of thousands of patents. They can't just populate the back of your phone, right? And you need to label your products if you ever enforce your patents, and they need to be labeled before you can get ongoing damages, right? So if you sell a product and if you're selling a product, you own patents, you're selling a product and you didn't label your patents, if you go to enforce patents on other your competitors, then you could lose damages because you didn't label your product. You didn't put the world on notice that this feature on your product is patented. And in order to get past damages, you need to do that. It's a very complicated area, but there's the example. That's why you have the labeling. Software, it's easy. You could load up a page full of the patents. Click here to see our list of patents. You can put it on your website. Here's our product. It's awesome. Click here to see all of our patents, right? So you don't have to put it on your product. And on your product, you can have a reference to the website or something like that, right? You could also use the documents that accompany your product if it is a physical product. Many ways of labeling, and the law is changing a lot, but it's you labeling products has changed a bit because of different innovations like the internet, right? And you can label things in different ways efficiently. So again, you don't have to litter your product full of patent markings, right?
Got it. All right, really interesting. So we'll add that to the next series.
Sure.
Discussion point. Okay, so last question, and I think I'm worried we don't have enough time really for virtual networking, but does Dave have a checklist of what level of protection is needed to protect something to the level of qualifying for a trade secret? So maybe you have a checklist?
Trade secret?
Yeah, what does it take to go to that next level?
Well, sure. So trade secrets, you need a couple things. First of all, you should have it, like we talked before, you want to have a time-stamped verification. So you have this disclosure of your trade secret. And again, you can't do this with every single trade secret you have, right? I mean, trade secrets include customer lists, right? And different things. And even trade secrets can even be the know-how of things that failed, right? You're not going to necessarily patent those things, but it would be extremely valuable for a company that is trying to copy you or compete with you to know what failed. You might have spent years of different trial and error, different technologies failing, right? I have a client that is in 3D metal printing, and they were spun off from Lawrence Livermore Labs. And they spent many years trying different ways to do area printing as opposed to the point printing, right? And so many different ways that they could try to do this, heavy light pipes, lots of lasers, lots of energy. And there are many things that failed because they found out that the most important thing is the cooling period for the metal. Now, they have several competitors that brag that they are doing the same thing, but they know what they're doing and they know exactly how they're going to fail. So knowing that, they're looking at their customers. I've never seen a client more comfortable with their position than them because they know exactly where all of their competitors are going to ultimately fail because they already tried that. Those are trade secrets, right? So you want to have it well documented. You also want to have, password protected. You don't want to have it in your public wiki. You want to be even careful on your internal wiki because the only people who should see your trade secrets are the people who need it to do their job, right? Not everybody needs to see your trade secrets. Not even all the lawyers need to see them. They can have access to them, right? But not everybody needs to see it. So you want to have restrictions on access to all of your trade secrets, not just within the doors of your company. Your receptionist might not need to see all of your technical descriptions, or software engineers might not need to see all the secrets in the hardware. I mean, it's those types of things, right? So you want to have those types of protections. And as long as you have these in place, and as long as they're reasonable for your type of secrets, your type of business, then you have it well protected. So, and the next question is, if somebody leaves and takes your trade secrets, what is the efficacy of going after them, right? If it's the Palantir example, we don't have records, you lose, right? So you have any of these things missing, then you're vulnerable to a trade secret theft that you can't resolve. And you want to make sure you have all those things in place, and you'll have trade secrets protected.
Gotcha. All right. Thank you, Dave, for another fantastic presentation.